So welcome to another one of our webinars here from Community Legal Centres Queensland. My name is James Farrell and I am going to introduce you to Tim Baumann in just a few minutes from MurphySchmidt, who's going to talk to us about an area that comes up often in community legal centres, where someone walks into an advice session and tells us that they've been left out of a will, probably of a family member, often a parent, and can explain what we might do from there. Before I do that, can I acknowledge the traditional owners of the lands on which we're dispersed or meeting or whatever it is that we're doing through this technology. Tim and I are in the Community Legal Centres Queensland office, so we acknowledge the Yagara people as the traditional custodians of this land. We acknowledge that everyone who's tuning in from across the country is living and working on Aboriginal land. We're hoping to make a recording of this webinar available to you, technology permitting. We emailed around a copy of the PowerPoint presentation a couple of hours ago. You should also be able to access that from the handouts section of the GoToWebinar control panel, so that you don't need to be scribbling madly as Tim's speaking. There are a couple of ways that you can ask questions. One is to press that button that looks like a hand on your control panel. We'll see something that looks like a hand going up at our end. We'll be able to unmute your microphone and then you can ask Tim a question that way. The other way that you can ask a question might be a bit easier. Just to type a question into that questions box. We'll see it pop up at our end, read it out and answer it. Hold your questions until the end if you can. Webinars aren't great for kind of conversational training, but if you do have a desperate question, again, press that button that looks like a hand or type something into the questions box. That's my housekeeping things dealt with. I'll hand over directly to Tim Baumann, who's, as you can see on your screen there, a Senior Associate at MurphySchmidt. Also, as we were just talking about, Tim is on the Management Committee of Law Right, formerly QPelch, for those that aren't up with the news south of the border, and so has, I guess, some direct experience in volunteering through Law Right and working with some of the clients that you'll be seeing in community legal centres who approach you when they're excluded for wills, and he's really well placed to talk to us about how we can help them. Tim, thanks very much. I'll hand over.
Thanks so much, James, and thanks everybody for making yourself available today. As James mentioned, I'm a Senior Associate at MurphySchmidt and my work is now solely in wills and estates law, encompassing estate planning, estate administration, and importantly for the purposes of today, estate litigation. As James also said, as a result of my own personal involvement and my firm's involvement with Law Right, formerly QPelch, I personally maintain an involvement in the Homeless Persons Legal Clinic and also the Self-Representation Service of the Court. And so I'm, I think, aware of some of the restrictions in our abilities to advise clients and people participating in these services in respect of these sorts of matters. One of the inherent difficulties, of course, in webinars is that I can't get a gauge of whether things I'm saying are being received well or not. I'm proceeding on the basis that they will be received well, but please, by all means, please let me know if you have any questions along the way and we'll see what we can do. I want to challenge the will, a phrase that is often heard from somebody who has come to a clinic who has a question in respect of estate litigation. I've said on the slide there, which you'll see, two ways you can do so in Queensland. I wasn't intending to restrict it to Queensland because this is in fact relevant across all states. I will say though from the outset that there is very much a Queensland slant, so to speak, in some of the procedural aspects of our discussion today, but there are some common themes which are relevant to people across the various jurisdictions. People talk about challenging wills, but sometimes they don't know what they're wanting to challenge it for. But really there are two ways. One is to challenge the creation process of the will. As those who have had some involvement in this area have come across it before, that usually involves arguments about testamentary capacity, or undue influence, you know, the sister being involved in the mother's drawing of the will, or testamentary capacity, things like, oh, they had lost their mind by that stage, or whatever the case may be. Also things such as formal requirements, such as the simple normal requirements for the creation of a will in Queensland. That's found in Section 10 of the Succession Act, which requires in writing, signed by the testator and in the presence of 2 or more witnesses. So those are effectively fall under that limb, the first limb being the challenge to the creation process of the will. We're obviously not talking about that today. We're talking about the second limb, which is bringing a family provision claim. Now, what people are saying there is that they don't like what the will says, and that is what the challenge ultimately comes down to, that they have either been excluded completely, or alternatively, that what has been provided to them they regard as insufficient. Just before I address these statistics, and I mentioned it very briefly, each state and territory in Australia has its own family provision legislation and its own requirements. And so whilst there are some decisions which are cited with authority throughout the various different legislative regimes, there are some process issues which are specific to each individual state and territory. I'm not going to try and address all those today because otherwise we'll be here until Christmas. But what I have done, hopefully it appears on your slide, is at the very back as an appendix to the slides, I've included something which all lawyers and people advising people in this area find useful, which are things like time limits. And you'll see on that appendix that it sets out each of the various states and territories and what the time limit is for bringing a family provision claim. So with that in mind, the first slide that you're looking at there is some empirical evidence that was obtained through a study that appeared in the University of New South Wales Law Journal in 2015. And I was interested in it because I hadn't seen somebody actually try and quantify the nature of claims that are made. Really quite amazingly on one level, but not amazingly on another, 60% of contested estates were valued at less than $1 million, and over half of those estates were worth less than $500,000. Now, that to me is a concerning aspect of this area because of the nature and effect of the costs or the effect of legal costs on the estate and its ability to erode a significant portion of it. But it just gives you a flavour, I think, of the types of matters that are being proceeded with are not, you know, the huge big estates necessarily. It can be under that $500,000 mark, which is sometimes the most vitriolic and some of the hardest matters to address. Over the page, we've also got a table extracted from that journal article as well, showing the types of claimants that bring proceedings, and overwhelmingly, or by majority, in fact, the claimants most representative in the matters that have been determined are brought by competent adult children. And that is what you see over and over again as being by far the most represented category of applicant, in my view, in these particular matters. I think a short history lesson is important. I don't want to bore anybody, but this informs, in my view, a lot of people's expectations when they go to see a lawyer or go to seek advice about family provision legislation. Because what you find is that people have varying degrees of understanding, expectation of what their rights and entitlements are that are often informed by what they've heard, seen. I heard someone say the other day that they heard something on the radio which told them a particular position. So people get their information from all different parts, and I think what's important is understanding the development of it. We will all appreciate that this idea of people dying without, or rather dying owning property is not a novel concept. It's been happening for many years. From the English common law position, the only question that used to be of relevance was, are you the eldest son? That was how property was passed down through the generations. And the idea of anything other than that at that time was quite a novel concept indeed. I've mentioned there the Magna Carta. That was the first recognition of forced shares that people could be expected to receive from estates. This was changed by the Statute of Wills in 1540, which was really for the first time in the English common law system where a testator could deprive their heir by will. Widows, interestingly, were still protected by a law of dower, which sort of preserved a third of their husband's real property for life. But again, that created some more developments down the line. I've mentioned there civil law jurisdictions, which have continued to operate on a forced share approach. And if you look at a lot of the European and South American countries, the idea that you can do anything other than give your estate to particular members of the family is a very, very novel concept. You know, family are entitled to a particular share on a particular basis in these countries, and that's how it has been for many, many years. But as in terms of the common law, as the 19th century sort of progressed, this idea of testamentary independence became more and more relevant until the Dower Act in 1833. And that was the act that allowed a husband to overturn that law of dower, which I mentioned before, and leave his entire estate to whoever he wished. And that was really the first acknowledgement of this concept of testamentary independence. What you have, though, of course, is when people can do what they want, they start doing what is unexpected from a social setting, and particularly at that time. And what you had was a lot of high-profile matters where very wealthy and noble individuals were deciding that their estate was going somewhere else. And that caused a bit of a stir, particularly in newly developing dominions of Australia, New Zealand and Canada at that stage, where it was very, very well reported. The first legislation that brought up the concepts of a family provision claim was in New Zealand, one of the another first for that country, obviously being the first nation to grant women the right to vote, was also the first nation to introduce this concept of being able to bring a family provision claim. As it currently stands, the only other nations that do are Australia, of course, Canada and the United Kingdom. Ireland and India have partial recognition provisions, but for the most part, Australia, Canada and the United Kingdom have the majority share. This, in my view, encapsulates the whole idea of family provision claims and is the principal public policy point. The making of provision for the maintenance and support of members of a family who are found in need when the family tie is broken by death. Sometimes it's very easy to just think that the only person you're going to see is someone wanting to challenge a will. It's not the case, because as you can appreciate, when someone decides to bring a family provision claim, there are other parties involved in that process who will be impacted by the result. I've mentioned there at the first point an applicant, obviously, who is dissatisfied with the terms of a will, or the distribution on the estate on intestacy is the number one person who you would immediately think of. Just as a slight side note, and importantly as well, you can bring a family provision application, whether it's as against a will or as against a distribution of the estate on intestacy. You know, the fact that the person died without a will and their estate has been distributed in accordance with statutory provisions in the Succession Act does not mean you are not entitled to bring a family provision claim. The second dot point there, a personal representative. You know, the executor is often going about their job, getting in the assets of the estate and looking at distributing them in accordance with the will, and then either out of the blue, or they might have had an inkling, comes an application or a letter from a law firm saying, we're acting for so-and-so and they are bringing a family provision claim. So they are also another party to it. And finally, other beneficiaries. You know, they are sometimes often the forgotten person in this process, which is they are advised that they have an entitlement, they have an expectation of it, and the next thing they know, they as well get a letter saying, well, someone's bringing a claim, and they want to disrupt what the entitlements of the people are under the will. So there are various people that are affected by these sorts of claims. Again, Queensland legislation will be the focus of our discussion today. I've got the section of the Succession Act there for your interest, for those who haven't seen it. Section 41. I've highlighted what are the key concepts out of that section, which is a little bit drafted in a bit of a cumbersome way because of obviously the history of the drafting of these provisions. But what it provides for is that a spouse, child or dependent in a Queensland context who has not been adequately provided for may apply to the court for an order that such provision as the court thinks fit be made for them. The concepts that arise from that, if we bring it back to, well, okay, this is all interesting, Tim, but how does that relate to what I'm going to see in my day-to-day experiences? Well, one of the questions that comes, well, who can apply? That's the first question that jumps out at me from that provision. What are the time limits? As always important in any sort of litigated matter. How do the courts approach the determination of these claims, and what other relevant select issues might we identify? Who can apply? As I mentioned at the very start of the webinar, changes from jurisdiction to jurisdiction. In Queensland, a child or dependent has the meanings that I've set down there. Stepchild is included in the Queensland legislation, as well as adopted child. Now, stepchild, as I say there, is dependent upon a relationship of marriage having been created or creating the stepchild relationship. You cannot be a stepchild if you are the child of a de facto when relating to a deceased person. Adopted children, of course, are the children under the Status of Children Act. They are children of the adopted parents. They cease to be children of the biological parents for the purpose of this Act. So that's an interesting point too. I think it's worth keeping in mind. And dependent there, as I have mentioned and set out, can be someone who is wholly or substantially maintained, but they must also be a parent of that deceased person, or the parent of a surviving child under the age of 18, or a person under the age of 18. So for instance, you could be a grandchild of a deceased under the age of 18 who's living with the grandparents, and you would qualify under this definition. Spouse, again, there's lots of various incarnations of what that actually means. Husband and wife from a married point of view, de facto, in accordance with the Acts Interpretation Act. You know, these principles are often seen throughout the other jurisdictions, living together on a genuine domestic basis for a continuous period of at least 2 years. Civil partner refers to the civil partnership legislation where people could register their relationships. And interestingly, dependent former husbands or wives or civil partners that fulfil the definitions that I have there. Whether or not they are able to bring a claim is dependent upon whether or not they are an appropriate applicant under the Act. If they are not, then they do not have an ability to do so. I've had clients say to me before, oh, I'm worried that my sister, my friend, whatever the case may be, is going to do something. Often that can be very quickly answered with, they are not an applicant under the will, or under the family provision legislation rather, and therefore don't have an entitlement to bring a claim. One aspect which, and there's a personal view, which I think could bear some legislative intervention, is the recognition of cultural family members from an Aboriginal and Torres Strait Islander community point of view. You know, I've acted for a number of Aboriginal and Torres Strait Islanders who have people in their family who they regard as brothers, as children, as mothers, as fathers. But the legislation, of course, doesn't recognise that. So from a personal point of view, I think that there's room there for that to be expanded to incorporate that. time limits, they pervade every aspect, of course, of litigated proceedings, and family provision applications aren't any different. I've bolded and underlined that in a Queensland context, the relevant date is 9 months after the date of death of the deceased. The appendix I have at the end of the slides provides the different timelines for the various other jurisdictions, which are reference to either the granting, the date that the probate was granted, or alternatively the date of death. You might look at that and say, right, 9 months date of death, that's easy. It's not as simple as that, unfortunately, because of, from a Queensland context, some of the other provisions which operate. I say there, so 9 months is the only time limit. Well, not really, and the reason why is for this. Under Section 44, a personal representative, so an executor or administrator, is protected from a claim made against them for distributions made in the following circumstances. After 6 months from the date of death, if no notice has been received of an impending claim for further provision, or after 9 months from the date of death, if notice of a claim has been received but proceedings have not been commenced. So what that effectively means is that the risk to the executor for making distributions from an estate and being held personally liable is really arises in the following circumstances. Before 6 months, if any distributions of an estate are made before 6 months and someone subsequently brings a claim, the personal representative is not protected. And the court may very well make an order that the personal representative be substituted as the respondent in their personal capacity. And the other aspect, before 9 months, if notice has been given. The Queensland legislation, which I'll touch on very shortly, provides a mechanism by which notice of a claim should be given to a personal representative. As soon as notice is given, a personal representative takes a risk indeed if prior to 9 months they distribute any part of the estate. The importance of giving notice can't be understated in a Queensland context. I've just got the requirements of notice there. It seems formal on the slide, but it's not. A letter from the applicant or the applicant's solicitor indicating an intention to give notice or giving notice rather of an intention to bring a claim will have immense impact from a point of view of protecting that person's right to bring a claim. And that can't be understated in a Queensland context because of the provisions about the protections afforded to executors, which I just mentioned. As soon as notice is given, what that should effectively do from the executor's point of view is stop them from distributing any part of the estate until either 9 months has passed and they haven't brought an application, or until the application itself has been resolved. So how does that have a practical application from the context of someone you might see? Well, if they're saying, they come in to see you and they say, well, look, these are the circumstances, I think I might have a claim. Giving of notice at least buys more time in order to get further material, further information if necessary, and should have the effect of stopping any further distributions from the estate being made. Like most time limits, there are powers that the court has to extend the time for bringing an application. In Queensland, I think this is similar in New South Wales, there are 4 indicia that an applicant must establish in order to convince the court to exercise its discretion. Very similar themes which you see where the court has discretion in other matters where it can extend the time, explanation for the delay, prejudice to others, any unconscionable conduct by the applicant, and the strength of the applicant's case. Hopefully that is not something that too many of your clients will need to try and get over, because it is difficult and it's certainly not something that just can be taken for granted. What is equally important in my view is an understanding of what in fact a family provision claim order, an order from the court saying that someone should get further provision, what assets can that actually be made against? The Act, as I've said in that first slide at section 41, provides that an order for further provision can only be made out of the estate of the deceased person. And former Chief Justice de Jersey and Baker and Williams provided a fairly succinct comment where he said, where there is no estate left, there is nothing from which provision may be made. And the relevance of that links in with some of our discussion already about the timing of an estate distribution and whether or not it was early, that is it was before 6 months, or whether it was after 6 months without notice and they were entitled to start distributing the estate if the estate was in a position to do so. So it is important from a point of view of advising people to have an understanding of what actually comprises the estate and also what actually is still in the estate depending upon the time in which they've come to see you. There are a number of things which are not assets of the estate. This might be elementary for some of you listening. It might come as news to others. Joint tenant assets are not an estate asset. It will revert to the survivor of the joint tenant. So if you have a client come into a clinic and says, oh, my father was rich, he had a $5 million property down the road, and it was with my evil stepmother, or they held it as joint tenants, but I should be able to have a go at that, shouldn't I? The answer is no, because it will not form part of the deceased estate. It will transfer and revert to the surviving joint tenant and will not pass through the estate. I've put a dot point there for superannuation. You could have a whole other webinar on superannuation. I don't propose to go through a chapter and verse today, but super is not actually your or my asset until such time as you qualify for its release either through attaining retirement age or certain things like that. What it is prior to that is it's the trustee's asset until it can release it. From a point of view of an estate planning and estate litigation context, if what they're saying to you is, oh, they had a whole lot of superannuation, well, there's questions there about whether it's in a retail fund, so Sun Super or Q Super or something like that, or if it's in a self-managed fund. But part of that goes by the way when you talk about whether or not there have been mechanisms put in place by the deceased to direct the trustee to pay those funds in a particular way. And the way that's usually done is by a binding nomination. Now, if the deceased had foresight or has taken steps to make a valid binding nomination in favour of a valid beneficiary, then that also will not form part of the estate. It will pay to that beneficiary directly. That's a really critical point. I have put there, though, that it can come into the estate if it is paid to the legal personal representative. You can leave a binding nomination that it be paid to a legal personal representative, or the trustee of the fund can determine to pay it there. So all is not lost because they have superannuation, but the question is, well, is it going to be paid to the estate or not? And that's a question that needs to be answered to determine whether or not it's an asset of the estate. Those last two things, assets that are subject of a valid gift during the deceased lifetime, obviously this can sometimes be a point of major discussion between litigants about whether mum gave the tea set 20 years ago to me, or and I just didn't get around to picking it up, or whatever the case may be. Invariably, the costs of litigating this issue make it a commercially silly manoeuvre to litigate over, but it is an important principle that anything that has been gifted during the lifetime of the deceased, and as long as it's a valid gift, doesn't form part of the estate. And finally, life insurance. And this isn't life insurance within a superannuation context. I'm talking about standalone policies. Sometimes they can be owned by two people. The policy can be owned by the spouse or whatever the case may be. So the fact that someone had life insurance doesn't necessarily mean it's going to form part of the estate. Importantly, when you have a client coming in, it's important to understand how a court decides these sorts of matters if it got to hearing. It is a two-stage process. I've got those two authorities down the bottom there which are often cited in this area. The first question that the court asks is often called the jurisdiction question, and it asks, has the applicant been left without adequate provision? If the court can be satisfied that they have, it moves to the second question, which is, well, what provision should be made for them? As I said, the first stage is considered the jurisdictional question and is determined at the date of death. That's important in a context of if someone's made a will 30 years ago, what are the circumstances of the applicant now as compared to then? Because the relevant time for determining that is at the date of death. The determination at the first stage, as you can see there, calls for a balancing of a number of indicia. This is certainly not exhaustive, but just indicative of some of the things the court looks at. You know, the financial position of the applicant. If the applicant, for instance, was a multi-millionaire, why would further provision be made for them? That's not to say that they're excluded as a result of that, but you would have a great difficulty in establishing the jurisdictional question for such an applicant. From a point of view of people seeing clients in a community legal context, it is not unusual to someone who is sole source of income is a social security benefit, no real assets to speak of. That is going a lot further to establishing that jurisdictional question. The size and nature of the estate, the relationship between the deceased and other people who might be able to make a claim on the bounty of the deceased. I've got the second stage there as well, which of course, if you overcome that jurisdictional question, it then becomes, well, what provision should be provided for this person? And the court looks at all the circumstances of the case, which is that lovely phrase, which means everything, and then determines what provision is appropriate. I'm just, again, not exhaustive, but a list of indicia which the court looks at and are relevant to a court's determination. Now, that last point, I think I made a bit of a mistake. I said the manner in which the deceased has conducted themselves in relation to the deceased. Well, that's not right, obviously. The manner in which the applicant has conducted themselves in relation to the deceased. But it's also, it also goes both ways. You know, if the deceased had been a very poisonous person who has created a hellish life for the applicant, that's not an irrelevant consideration by any stretch of the imagination. The last point, what about fairness? This is probably single-handedly the most often quoted phrase for any client that I see in a family provision context, but it's not fair, or it is fair, or whatever the case may be. The court is not seeking to make it fair. What the court is seeking to do is recognise people have testamentary independence, but that in circumstances where there is a need there on someone, on an applicant, it is seeking to address that need. So the first question the court asks isn't, okay, well, how many kids are there? Okay, well, how many people are getting a share? That's not how it works. So do everything you can to dissuade whoever you are seeing that it is not about fairness, because for better or for worse, that is often the way in which they are assessing this. If they are a very deserving applicant, but they are one of 3 kids and have been given a 3rd share in the estate, some people might never even come and see you or I. They, for better or for worse, will look at that and say, no, I'm one child, 1 out of 3, that's appropriate. So it is a concept which is throughout this sort of area, but it's important to understand that that's not what the court is trying to do. Jurisdiction, of course, is always important. So let us once again come back to advising someone in the 20 minutes that you have. They give you a bit of a rundown of the assets of the estate. They give you a bit of a rundown of their own circumstances. You're starting to form a view that, well, okay, look, they might have a claim that certainly is worth investigating further. In Queensland, the jurisdictional limits there are the Supreme Court over $750,000, the District Court under that amount. There's a question there as to whether that should be, is the estate over 750 grand, or is it that what they're claiming is over 750 grand? The way I look at it from a practical point of view is the court can award further provision by way of the entire estate. And so my view of that has always been get an understanding of what the estate value is, and that often determines your jurisdiction. In Queensland, we have a very descriptive practice direction in both the Supreme and District Courts, which really determines the conduct of these sorts of matters. I've got the details there, number 8 of 2001. That really should guide any applicant that you see. You should be able to print it off, give it to them, and that already has put them on a much better path than they would otherwise be. Because what it does is set out a number of things which I'll address very shortly, but it talks them through how the actual process should unfold. And so it's a very good thing to have a look at if you haven't already. In Queensland, it's a Form 5, the originating application. Once again, these are more dot points to bear in mind if you're being asked to assist someone to prepare it, or someone's interested in what they've actually got to say. Firstly, obviously, they've got to seek adequate provision. That's what they're asking the court to make an order about. If they're self-represented, this next issue is a little bit less relevant, but if they are represented, the cost of the application be assessed on the indemnity basis. A couple of other points there. If it's being brought outside of time, you've got to say that it is. If it's being brought without a grant having already been made, the relevance of that is, in my view, not as significant, but you've got to say it if it is. And finally, and this is a not as well used part of this area, which is the ability of the applicant to exonerate from their application any gift in the will which they don't want to be part of the pool of assets to consider for the court. Perfect example of if the testator has given 4 $1,000 legacies to the bridge players that they played with, who have had no otherwise involvement, the applicant should, in my view, think very seriously about what assets should be exonerated from their application, because it doesn't seem at all sensible that you involve in a litigated process legacies or beneficiaries who either receive a very small legacy or the applicant doesn't have any real concern receives the legacy that they've got under a will. And finally, and this is important once again from a Queensland point of view, most of the originating applications have a returnable date for the registry to insert when you file. You take those out for the Form 5 and you put that last clause there that the application will be heard by the court upon a date to be fixed by agreement or failing agreement after not less than 14 days. So that just means that, importantly, when you file it, the court doesn't set it down for 3 days' time, because that's not how these sorts of applications proceed. Service is important from the practice direction point of view, but also from assisting clients to understand the process. It's not enough just to simply file the application, and I'll caveat that and come back and speak about that. What should also be filed is the supporting affidavit, and the draft directions order doesn't need to be filed. But when you're serving it on the personal representative, the application, supporting affidavit and a draft directions order should be delivered at the same time. Those requirements are set out in the practice direction. There are some interesting aspects in a Queensland context of what filing an application does. It protects the interests of all persons who might apply. That is quite, in my view, a really quite, not bizarre, but a very interesting provision from the context of all other litigation. I'm unaware of another ability of someone in another litigated process to protect the interests of someone else by their filing to protect their own. But that's effectively what that provision does. If you're advising a client and you can do an electronic search of the court file and it shows that someone has already made an application, that will protect the interests of the person you're seeing to pursue an application as well. So that's something to bear in mind. Sometimes it can give or result in a rather bizarre, almost sort of chicken scenario with the people who are intending to bring a claim, who's going to go first and spend the money to pay the filing fee. But obviously the bottom line is that if someone has already made that application, then it can protect the interests of anyone else who wishes to. The second point I've got there, the application only may be filed. I mentioned before that I caveated my previous remark. That should really be reserved for only urgent applications. If you're seeing a client 2 days before the limitation period expires of 9 months, you don't really have the time to get together a 25-page affidavit dealing with all the indicia which the court will want. An application should be filed, and in the draft directions order you make provision for when the applicant will be filing their affidavit. My view is that's the appropriate way to do it. And that last point goes without saying, but it should be served immediately on the personal representative, because without notice of the application, they could get the protection of those sections that I mentioned earlier on. Once again, I don't want to go through each of these one by one. This is the indicia under the directions order that the court is entitled to expect an applicant addresses in their affidavit, things which you'd expect, you know, assets and liabilities, sources of income. Are they an applicant? You know, establish that. Any bequest that they want to exonerate, any other information, and finally, any other such material that may be necessary. What I would certainly counsel against is using that last point to let an applicant or a client raise every concern that they have ever had in respect of the executor. You know, they called me this name when I was 9 and I never got over it, and, you know, these sorts of things. I don't want to make light of them insofar as to say relevance is of high importance in these affidavits, and there is often so much vitriol and pent-up emotion that what the client often wants to get down in paper might not necessarily be the best for their application. So it's important, as people who advise and give you know, assistance to people preparing these documents, that it is important that it be kept relevant, and that is the focus of the preparation of the application. Again, the directions order, the dot points that I have there are the timeline and the way that the application will be dealt with from a context of the progress of litigation. The draft directions order envisages a dispute resolution plan, and the vast majority of these matters settle during a mediated process or some other dispute resolution process. And the reason why is because the costs of litigation are so prohibitive that usually applicants can, and I say usually because not all, but usually they can appreciate the commercial reality that if they're trying to get a benefit of an extra, you know, X thousand dollars, but it's going to cost them that, and there's a risk that they, for whatever reason, you know, it goes the other way, usually they can be reasoned on that basis, and that's why alternative dispute resolution processes are often so successful in these particular matters. I mentioned before that it's very easy to just think about applicants in this process, but the role of other parties is important to understand as well. The personal representative, for one, you know, that is often someone who is also a beneficiary, or someone very, very close to the family that the testator has appointed because they knew there might be an issue, or they knew this could happen and they thought the executive they've appointed is well placed to deal with it. The primary duty is to uphold the will. That is their obligation as executor. It is not just to simply roll over because someone has brought an application. I caveat that by the next point, which is the duty to compromise. There is a fiduciary duty, in my view, that the executor not defend an otherwise meritorious application for the sake of upholding the will, when to do so will simply erode the estate and result in the beneficiaries getting less than if a sensible commercial resolution is reached. So I put those dot points there for personal representatives to be aware of, because you might have someone who comes in and says, look, I'm an executor, I'm doing it myself, I didn't want to get a lawyer involved, and you know, this has occurred. And so it's important they understand what their obligations are. For an interest point of view, I've also got there, well, what if they're an applicant? Often the executor is the son of the deceased or the daughter, and they may also be a beneficiary. Some people have weird ideas about the appointments of executors, and I would never put it past someone to appoint someone on the basis that, oh, well, if they're the executor, then they can't make a claim. Well, not true. Under the Trust Act in Queensland, trustees and executors can be represented in different capacities. The practical reality of how that would play out is if the executor was appointed with someone else as a co-executor, the proceedings would be brought against the co-executor, and the executor would not be an executor for the purpose of defending the proceedings for obvious reasons. beneficiaries as well. You know, as I said earlier in our webinar, they are often the forgotten person in this process, and that is the person who, for whatever reason, they have been provided with an entitlement under the will, and then they are given notice of someone's intention to claim. The claim is proceeded, and they're then advised that, well, in order to resolve this, you're going to have to take a haircut in terms of what your entitlement is. So there are these people there that are affected who aren't applicants and executors, and it's important to bear those people in mind as well, particularly when you look at that first point, that any order for further provision is to fall ratably on the beneficiaries. So any resolution has the potential to affect the beneficiary's share. This question of, well, okay, I'm a beneficiary and I've understood someone's bringing a claim. Do I need representation? You know, do I need to have my own lawyer? Well, what I would say is that there is authority that those with common interests should avoid separate representation. For the reason being is that if 5 sets of lawyers are sitting there looking at each other across the table, that's 5 sets of legal fees when they're all arguing the same point. So the first position should be, well, are there parties with common interests? Because if the executor is doing their role appropriately, then they should be able to uphold the will. If a beneficiary chooses, for whatever reason, be it personality or there are different interests, they argue, then there is a risk that the cost of representation won't be allowed if it went to hearing, subject to them being able to justify having separate representation. You know, beneficiaries also have to consider, well, should I bring my own claim? If you haven't seen the practice direction, it envisages the executor writing to any beneficiary or person who could be themselves an applicant and asking them, when you respond or if you intend to be represented, you also give notice of your own intention to bring a claim if you wish. That's effectively the thrust of it. So as a beneficiary, they may have been otherwise satisfied with their entitlement under the will, but as soon as their brother, sister, whatever the case may be, brings a claim, that might say, well, hang on, my position is a lot worse than them. And so my view is that has changed my position. I'm going to bring my own claim. Whether or not a beneficiary is under a disability is important. In Queensland, the Succession Act under 41 allows personal representatives the ability to bring a claim on behalf of someone under a legal incapacity or apply to the court for advice and directions as to whether they should do so. And obviously the normal provisions under the UCPR, the Uniform Civil Procedure Rules about the appointment of a litigation guardian also allows that to occur. Settlement. What if someone is coming to you and they think a settlement can be reached or alternatively one has been reached in a mediated process? This has been discussed and has seen some interesting developments over the last 5 to 10 years in a Queensland context. Unlike other jurisdictions where a family provision order is considered an amendment or a codicil to the will, it is not the same in Queensland as how an order for family provision is made. And so what the legislation and the case law has said in particular is that because it requires the court's discretion, the court needs to be the one to make final orders in respect of it. Now, I've got the 3 authorities there of Watson Public Trustee, AFU and the Public Trustee, and the Court of Appeal in Abrams. You know, the Court of Appeal in Abrams is the most recent authority, I think 2015, and is, in my view, very clear. If you are going to have a proper disposal of a family provision claim, it has to be by way of final orders obtained from the court. Now, the problem with this, from a point of view of estate litigation and the size of estates, is what that means is that, okay, so we have to spend more costs, the estate has to expend more money in dealing with simply getting what some applicants may, oh, they're just going to agree, aren't they? You know, these sorts of arguments. The question, of course, is what does the case law say? In my view, it is clear. But there is a practical reality, of course, with this. For the last 5 to 10 years, people have been resolving these sorts of matters by way of deed alone. But in my view, the cases are clear, but it's important not to be completely removed from reality, and the fact of the costs of these hearings can sometimes add a further and unnecessary anguish on top of an already under pressure parties. And so in particular types of circumstances, and as long as clients are advised of the risks, they may be instructing you to simply do it by way of deed. Now, as I said, my view is the case is clear. I would never do that for an executive, as the executive is one bearing the risk. But the instructions may be that after being advised of the risk, they just want to simply dispose of it by way of deed. My view is that is a practical solution, but it does not marry up very well with the case law. But at the end of the day, we give advice and we advise clients of risk and what the law is, but we obviously act on their instructions in a particular way. We're starting to certainly get to the end, and what I wanted to just plant in everybody's mind before we wrap up is some questions which I think are going to develop further in this area. I was mentioning to James at the start is that this area will always require a legislative framework to deal with, because the reality is that no one gets out alive. There always has to be law dealing with the distribution of estates and what happens in the event of death. Add to this Australia's ageing population. Add to this the increases in blended families. It's not uncommon for many marriages now to have occurred. And add to this increases in personal wealth. The person who bought the house down the road for 20 grand 20 years ago and now it's $1 million. There are things people are going to now try and litigate over. No one's going to litigate over the Datsun 120Y, but if there's $1 million property, it's a little bit different formula. I can't understate the issue of costs on estate disputes. I've had clients where you are absolutely at pains to explain to them that the merits of the application that is brought, or the merits of the application they bring, or whatever the case may be, has an immense risk or is likely to fail, or whatever the case may be, but the costs are so prohibitive that people just have to be commercial about it. And if they are not, then the beneficiaries are going to be the losers and the lawyers are going to be the winners, and that is not in the interest of the client. I've mentioned that case there about cost capping. The judiciary has started to really show a desire to intervene in matters where it sees to be, and I've mentioned in that second point, an abusive process. If people are spending $300,000 in legal fees over a $400,000 estate, be prepared to cop a hiding from the judiciary. They just will not cop that, and nor should they. So the issue of cost should not be understated, because it is immensely important, and commerciality should be at the forefront of everybody's minds. And in those circumstances, of course, you can't ever discount the fact of, or the risk that a court may seek to visit the burden of the costs on the solicitors representing the unmeritorious applicants or parties. So it's always something to bear in mind. Once again, I didn't address in any real detail today's superannuation benefits, but I'm seeing a whole lot more, and particularly in a community legal context. Someone coming in saying, oh, they didn't have anything, but they had $2 in their superannuation, and within that superannuation, they had a $500,000 death benefit. Well, that's $500,000 that is, in their mind, up for grabs in any sort of litigated proceeding. Now, as I said, it doesn't automatically form part of the estate, so it does not necessarily mean that it's going to be a family provision claim, but it could be a litigated claim through the superannuation, the Commonwealth scheme, the Superannuation Complaints Tribunal, which is a long and often difficult process to navigate for a whole lot of people. But because of the money that is there, it creates a big target for a lot of potential litigants. That final point of legislative intervention, my view is that there is a noticeable swing in the pendulum from the judiciary, and I think it will only be some time before the legislature pick it up, particularly in the context of adult children. From the statistics I showed at the start, a huge percentage of claims are being made by competent, financially comfortable adult children who are dissatisfied with what their parents have done for whatever reason, and the question must be asked, is that a proper function of family provision legislation, or is it an unwarranted intrusion into testamentary freedom? So look, thanks everyone for listening in today. By all means, if we have any questions, I'm happy to take them, but I'll just hand back to James.
Terrific. Thanks, Tim. Wow, plenty in that for all of us. We're just going to rearrange our chairs a little bit here so that we're both across the microphone. While we do that, a reminder that people can ask questions either by typing a question into the questions box and putting up their hand. Tim, we've had a few questions comments. Great summary. It's been fascinating. Thank you. This question here I might read out. What if there are certain items to be distributed? For example, the will may state that I leave my son my diamond watch and the watch is given to that son before the 9 months is up. Would the personal representative be liable there? So we're not talking about cash in a bank account, but particular material items. How might that change an application for family provision?
Sure. My view on that is with reference to those protections to the personal representative section. If the distribution of that item to the son or daughter occurred after 6 months, and your question refers to it being before 9 months, without notice of an intention by someone to bring a claim, my view is that is a valid distribution that no longer forms part or part of the pool of assets that could be the subject of a family provision order.
Terrific. Tim, can I ask you, quite rightly I think focused on the litigation process, can I ask a little bit about the negotiation or attempts to reach settlement before proceedings are even issued? So a client comes into Community Legal Centre, says, I was left out of Dad's will. As a lawyer, we take the view that they have some entitlement or there's a likelihood of a court order being made. Leaving aside that question around a deed or needing to get some kind of sanction by the court, does it proceed any differently to an ordinary commercial negotiation to and froing of the parties, or are there things that we should be mindful of in those negotiations or conversations with the personal representative?
Sure. My view, particularly in this area, is the earlier attempts at trying to resolve it are clearly in the best interest of everybody. Part of the strategy that certainly I employ if I act for somebody in a family provision claim is get as much information as you can. If you're well within the time limit, obviously give notice to protect from any further distributions. Give notice to do so, but then the early delivery of particulars of the family provision applicant's circumstances may very well prompt informal negotiations that could see it resolved in a matter of weeks. And I've had matters before which have done just that. By setting out their circumstances, the executor or the personal representative is much better placed to start putting on their negotiation hat and seeing whether or not it can be resolved. You're exactly right. Before you get to deeds and settlements or the rest of it, but my view is that the early attempt of parties to negotiate is really advisable, because the bottom line is that sometimes these things can snowball. Well, you get an affidavit, I'm going to get an affidavit, I'm going to have my friend get an affidavit, and it spirals out of control. And then the problem is that too many costs or too much cost has been expended, and it requires a formalised mediation to resolve it, which again is another 50 grand or whatever the case may be. So, James, I absolutely agree. The early attempt at a resolution is advisable, particularly given the interesting dimensions which sometimes present themselves in these sorts of areas. And what I mean by that is, sometimes people aren't after another 200 grand. What they're after is a particular item, or what they're after is, this particular thing, or whatever the case may be, but the way that has manifested itself is, well, if you're not going to give it to me, I'm going to attack the whole thing. And so if those personal issues can be addressed quickly and sensibly, my view is that's a great way to go about it.
And when you talk about particularising the circumstances of our client in the Community Legal Centre, that would be done again as an ordinary kind of exchange of correspondence rather than necessarily. Is there to what extent are there particular processes or rules that we need to be aware of in this space that would vary from ordinary civil procedure rules or processes?
Yeah. In an informal negotiation context, I think there would be a lot of similar themes throughout. The way I would approach it, if I had someone coming into a community legal centre and say to me, this is the circumstances, the first thing I tell the client is to, have you got a copy of the will? That is the number one, because without a copy of that will, you don't know whether you've been left out at all. You know, I had a client the other day who swore black and blue he was left out. Look, I know I'm going to be left out. The will came, sure enough, he'd been treated equally with all his brothers and sisters. Now, he was blown away by that, but that had been informed by comments he had heard from his brother or comments he had heard from his father. So the number one starting point is get a copy of the will. What I should say, and actually I should have put this in my slide, is that under the, I think it's 33Z or whatever it is in the Succession Act, children, family provision applicants are entitled to a copy of the will. No one should be saying to a potential family provision applicant or child, I'm not giving you a copy of the will because you're not in it. No, I'm sorry, you have to give a copy of the will. So as soon as they've got a copy of the will, they then know what they're dealing with. They need an understanding of the assets and liabilities as well, because it's no use saying to a client, look, you've got excellent prospects, you're disabled, or whatever the case, you're impecunious, you don't have any funds, but then there's $5 in the estate, it doesn't matter. So get a copy of the will, assets and liabilities, and then once they are received, full disclosure of the circumstances of the applicant. You know, I'm a single parent, I'm not, I've got a child, the child has needs, all these things are relevant and will assist in early resolution.
You talked about a family member or a potential applicant here having entitlement to a copy of the will. Does that entitlement extend to a statement of the assets and liabilities of the estate?
It's a really good question. The section of the Act does not contain any description about assets and liabilities. So it doesn't say you're entitled to a will and the assets and liabilities, but it's really by extension that you're entitled to that. And the reason why is because under the practice direction, they are required, that is the executor is required to identify the assets and liabilities. So by extension, you say, well, okay, you don't tell me, let's proceed down this path, and you've got to tell me anyway. And so the bottom line is that a request for assets and liabilities should never be met, in my view, with a unreasonable refusal.
Final question, I think. You spoke about registered civil partners being a family member for the purposes of these rules. De facto partnership, does that extend to same-sex couples, or what are the variations, I guess, in definition around same-sex couples and the need for reference to a civil partnership scheme that has kind of drifted in and out of Queensland law in recent years?
Yeah, it's a good point. Given the Civil Partnership Act, if you are a civil partner, you're considered a spouse for purposes of the Act, number one. Number two, same-sex couples may be both. They may have their relationship registered, and they may also be a de facto for the purpose. Sorry, I've got myself tied up there. The de facto same-sex couple who haven't had their relationship registered are still a spouse for the purpose of the Act. So whether you are a civil partner or a de facto in a same-sex relationship, you still, as long as you qualify with the other indicia, you will be fine.
Terrific. We might pull up some today because we have gone a few minutes over. Can I, on behalf of people clapping and cheering while the computer screens across the state, Tim, thank you for that presentation. As I said, it's something that comes up relatively and surprisingly, I think sometimes surprisingly frequently in community legal centres. We're seeing some fantastic feedback coming through on the GoToWebinar, so thanks to everyone that's sending that through. Can I also thank everyone that did participate? We, as I said, hope to have a recording of this made available, and we'll distribute that in the next couple of days, and look forward to speaking to you on another webinar soon. Have a great night. Thank you.